Hello and welcome to Legal Angle, the legal discussion program where we talk about issues in the news
from a legal perspective. Hi, Ken. Nice to see you this evening.
Good to see you, Matt. I'm Ken Parker. I'm here with my co-host, Matt Yospin. And we have, Matt, I must say, a fabulous show for our audience tonight. Do we not?
I believe we do. I'm looking forward to it. We're in our new, relatively new hour-long format.
Right. Which is, I think, our second hour-long show.
Yeah.
Allowing us to take a deeper dive into issues in the news.
Right, exactly, which is important because as our regular viewers and soon-to-be regular viewers know, we talk a lot. And this way we get
always insightful, though, right?
I believe so.
A little touch of humor perhaps mixed into the broth?
No guarantees. And this way we can go into more depth in often more issues. Usually
well, I think
we've
that's
been able
appropriate
to cover
this week. You know, that like there were a lot of stuffing into the turkey, you know, so we're going to talk turkey, and we're going to stuff as much in as we can.
That's right. Although, to be fair, no turkeys were harmed in the making of this television show.
To the best of our knowledge. We're lawyers.
That's right. That's right.
I mean, where did maybe someone dropped the monitor on a turkey for all we know? There's a lot of turkeys roaming around.
Okay. That's right. To the full extent of our knowledge, upon information belief, no turkeys were harmed in the studio while we've been here.
I think that's fair to say.
All right,
I believe I have direct knowledge of that. Anyway, Matt, let's get into our topic list because there's so much. It's been a little while since we did a show, so we're going to need to catch up on a few exciting issues. Yeah. So we have a docket tonight.
That's right.
We've never had a docket before. This is a new feature.
I mean, we may occasionally have had a docket, but we definitely do tonight.
Yeah, I don't think we've ever called it a docket anyway. Anyway,
so
here we are.
First up. Justice caught in a pickle. The first topic we want to cover is about Grillo's Pickles, a local company, and pickles.
Yes.
Next up, the topic of AI, generative AI, large language models.
AI ate my book.
Yeah.
Delicious.
We'll give you more detail on that as we go. Not the same as pickles.
There's a lot of eating going on. You see the theme here, pickles, eating a book. And what's the next one, Matt?
It's that a court, a trademark examiner, but in this case a court, takes a bite out of Apple computer,
out of their trademark application.
Out of a trademark application.
So yes, this is a very Thanksgiving eating themed
yeah, sure.
show.
Yeah, you know, pickles, books, and apples, the traditional Thanksgiving meal.
Eating things. Well,
yeah. And last up, some decisions.
Apple pie.
Yeah, okay. Some decisions from the Supreme Court. That is the ethically challenged court in question. We'll be talking about some of their recent decisions.
And why they're ethically challenged.
And what, if anything, they've done to address that.
There's been news.
There has been news.
They have guidelines.
It's an issue in the news. We'll bring a legal perspective on it.
I can't wait, Matt.
All right. So let's dive right into this
Matt,
vat of pickles.
Matt, what's our first topic?
Grillo's Pickles. In a pickle. So this one we've headlined Justice in a Pickle. Justice caught in a pickle. Okay, Grillo's Pickles, local company. What's in the news, Ken, and what's the legal issue with it?
Well, so Grillo's Pickles is suing a New Jersey company saying that they stole their secret recipe to their pickles, because pickles have a recipe, you know.
Sure.
What makes them even that distinct taste.
I've made pickles. Do you follow a recipe or risk the consequences?
And some recipes, of course, are in the public domain. Many recipes are in the public domain. But one of the fun things about this case, and by the way, that photo of the Grillo pickle, that was from Fenway Park.
Yep.
That's
which is appropriate because that's, I believe, where the guy started selling pickles, was on the streets around Fenway.
I did not know that. Thank you for that tidbit. But anyway, what interested me in this case, Matt, is that it's about trade secrets. We don't talk enough about trade secrets, I think, because to me, they are the secret weapon in intellectual property.
Secret.
Yeah, because everybody knows trademarks.
I see what you did there.
Oh, I'm glad you enjoyed that. I thought that would slip right by. Because everybody knows about trademarks. They might not know the difference between trademarks and copyrights, but they've heard of both of them, right? And everybody knows patents deal with inventions.
So what's a trade secret?
So a trade secret is really any piece of information that your business has that conveys a commercial advantage that you keep secret. And so it's so powerful because there's lots of things, as you know, as a patent lawyer, that are not patentable. You just cannot patent, for example, a recipe.
That's
Can't
right.
be done.
No, you cannot.
Say you make a fizzy soda, for example, and it's very popular, and you don't want other people to make your same fizzy soda. You know, you've heard of this small company, Coca-Cola, I believe they're called?
Yeah, it's come across my desk once in a while.
Yes, and down your throat, perhaps?
And sometimes I clean it up.
Yes.
Right, no, I understand. So a trade secret is something that is commercially valuable and that you keep secret.
So it doesn't have to be a recipe, by the way, and this is what, like a lot of our clients will be like, well, our business doesn't have any intellectual property. Well, of course, as you know, Matt, no business has no intellectual property because everybody's got a brand, right?
That's right.
So that's a trademark right there.
Yep.
And almost everyone's got some images, descriptions, a website. So that's copyrightable subject matter in most cases, marketing materials. But one thing that a lot of businesses, the thing they most value and most want to keep others from taking is often their customer list, their formulas for doing things, maybe their recipes if they're a restaurant. And those things are all protectable as trade secrets. And you may ask, Matt, or someone may ask.
So what do you have to do to make something a trade secret and keep it secret?
I'm glad you asked.
Like, can you just say this is secret and by so declaring it's now a secret, a trade secret?
There is a list of things that we advise our clients to do if they want to keep something secret. One is agreements with your employees that they won't share that information with others. Another is to limit access to the information to a need-to-know basis in your business. So, for example, if you've got a list of your customers and a customer database, you don't let just anyone in the office access it. Maybe you put it behind on a password-protected server, and only the employees who need to do that marketing get access to it, and only the parts of the database they actually need access to. So that's the first thing you do. You take reasonable steps to keep it confidential. And then, of course, it has to be of some commercial value. It also obviously can't be something that's widely known. You can't turn something into a trade secret that everybody in the industry knows. On the other hand, it's not as strict as a patent standard. So you don't need, for a trade secret, for it to be something that nobody else knows. It could be known by some other people, but as long as it's not generally known. With a patent, if even one other person has published something on it, or
right, then it may not be a new invention,
right,
and not eligible.
It's a very high standard.
Yeah.
Whereas with trade secrets, there's a lot of things that people can generally know, various people in various companies. So this case is also interesting because it follows the usual pattern with our clients of trade secret in misappropriation. They don't call it infringement; they call it misappropriation.
So the pickle company, Grillo's Pickles,
yes,
had a trade secret, or at least one, their recipe.
Yes.
And what they said in the lawsuit is that their co-packer, I think someone who was making pickles and packaging pickles for them.
Patriot Pickles.
With them. Patriot Pickles, based, I think,
stole their recipe.
Nearby in New Jersey, stole their recipe and started making its own pickles.
That taste using their recipe.
So
this would be like a Coca-Cola employee taking the Coke recipe and making, starting Joe's Soda, Joe's Cola.
Right.
And
right. So you know with Coca-Cola, for instance, that trade secret has been maintained, so far as anybody knows.
For more than a century.
For more than a century. And all you have to do to test that is go taste some other sodas. And even if you're not a connoisseur of sodas or a professional food taster, people can tell. Coke and Pepsi and RC Cola and Moxie.
Yeah. Maybe not everyone can tell, but most people.
But they taste different.
Yeah.
To most people, they taste different, even if you can't say exactly why. Well, that's the secret, right? That's the recipe.
Right.
So with these pickles, their co-packer, who presumably, I believe they say, had contracts in place.
Right. So this is the key. If you don't have a contract in place saying it's a secret, the most common scenario is a former employee who knows all your business secrets, goes off and starts a competitor, maybe even in the same building, right down the block. When they set up that competitor, if you don't have an agreement with them that says this is going to be a secret, you could be you may have given away the secret, essentially.
Now, it might still be actionable, as unfair business practice.
Oh, absolutely. And there may be other clauses in their employment contract. Non-solicitation or non-compete might be relevant.
Right.
There may be other things.
Right. But the secret nature of a customer list or some know-how that they gained at the company.
Yeah. So, but here's the funny thing, though, also, Matt. Some of these things, like the non-competes, are really frowned upon, and now you have to have garden leave pay. It's really hard to enforce a non-compete. Non-solicits tend to be have to be very specific about not soliciting former employees or customers, whereas trade secrets are so much broader and more enforceable. We won a trade secret trial this year, and it was for a nonprofit. Some people who worked at that nonprofit took the nonprofit's volunteer list and went and started a competing nonprofit, and solicited those people and also badmouthed my client, and so we had a jury trial and won a trial. So that's the kind of thing, though, that provides a lot of protection. And so we don't know what's going to happen with this lawsuit yet, but I would say that Patriot Pickle is deep in the brine, and they're in a really tough pickle right now.
Caught in a pickle?
Yeah, they're caught. I believe they are caught in a pickle. Yes, and so
what a bad dilly that is.
Oh wow!
I'm trying, Ken. There's only so many pickle-related puns that come readily to mind.
I can't cucumber any others.
That doesn't even sound like a pun.
It's not. That's why I said it. All right, Matt, I want to ask you about our second topic.
Let's move on to the next course.
We better before I think of more puns in our audience.
Okay, next.
All right, so Matt, we've talked about OpenAI before.
Yes.
And AI in general, generative AI, they can make pictures, they can make text, and people are saying, oh, this is a threat to creative folks, to artists and writers. And for the first time this year, 2023, writers have started to file lawsuits against some of these AI generators. And we've got some really interesting things that are happening in these cases, but some really well-known authors, including the guy who wrote Game of Thrones and will never write the 6th book in the series, apparently. George R.R. Martin is one of the plaintiffs in one of them. And there are a lot of famous authors that have filed these lawsuits. My question is, Matt, can these what are they suing about? What are these generative AI companies like OpenAI allegedly doing? How are they eating people's books?
Yes. So I'd like to first note that the artwork here was largely created by a generative AI platform. Actually, it was OpenAI's. I used it. So that artwork that you see on screen behind us is largely not protectable by copyright under current copyright law.
Well, you did add some human elements there, though, as I recall.
I did. So it's possible that the work overall might be protectable if someone judged that the elements I added, which are the copyright symbol and OpenAI's logo, both made in red, a shade that I chose so it would stand out, are sufficiently creative elements placed on the scales of justice on opposite sides to illustrate the topic, which is...
I think it's lovely, Matt, and I would be willing to register the copyright to that. I would think that would be...
I will take you up on that. Okay. We would just have to be sure to disclose, of course, that part of the material was created using a generative AI, which is a requirement for any copyright applicant, whether you're filing a new application or in a pending or issued registration. You need to
disclaim public domain material.
Not just public domain, yes, but not only that. You need to specifically say if any part of the work that you're trying to register was made with a generative AI.
Oh, that's right. They've just issued those regs.
That's a fairly new
brand
reg.
new.
Yeah, and it applies, like I said, retroactively to anybody who's already registered something or
they need to amend. That's true.
You need to amend either a registration or a pending application. So if we tried to register this, if I tried to register this as the author of this amazing work, I would be sure to say that.
She looks very angry.
You know, it's a strange image. Okay, let's go back to the cases.
So Matt, how would AI eat a book? What is this lawsuit about? Or which lawsuits are we talking? There's two recent ones.
There's several. Okay. Please don't ask me to recite from memory their names right now, but they are class action lawsuits. One I know is involves as a plaintiff Michael Chabon. I think that's how his name is pronounced. He's the author of The Amazing Adventures of Cavalier and Clay, a really fun read.
I believe he's a Pulitzer Prize-winning author.
Yeah, I think so. And there are several others. They're class action lawsuits, all revolving around the same alleged set of facts, which is that OpenAI and Stability AI, to build their large language models and train them, ingested thousands, hundreds of thousands of works, including their own books. Another one in one of the lawsuits was, I'm forgetting the author's name right now, forgive me, The Madhouse at the End of the World, which looks like a really interesting book. I'm putting it on my list to read.
Okay.
But my list to actually read myself as a human.
Not have a computer read and feed into your brain somehow?
Exactly. So what these authors are alleging is that this large language model, the AI, was trained by reading their books.
What does that mean by trained, though, Matt? What are we talking? What are we actually talking about?
So, to make a large language model, these text-based word generation tools, they have to read a lot of material, and books are one of the main things that they read.
So we've talked before about the output of these models.
Right.
Right?
This is for to create them, the input.
Right.
They have to take.
So how is that different, Matt?
Well, I mean, how is it different to,
Well, what I'm saying
to read a
is,
book or write a book?
Just to be clear, what we've talked about before, just for the remind our audience,
Okay.
is if OpenAI generates something and an author goes, wait a second, I wrote this. This is just taking whole blocks of text from my book. This is infringing my copyright. Why is that not what's being they're suing about in these cases?
Well, that's not what they're alleging, because so far as I know, people aren't using the OpenAI chatbot, ChatGPT, or any of its iterations, to say, hey, I want you to generate for me a copy of The Amazing Adventures of Cavalier and Clay. I haven't tried that personally. I don't know if anyone has. I suspect that the software has in place controls to prevent it from replicating and producing a copy of somebody's book.
Well, to be clear, people have used OpenAI to try to write The Winds of Winter. You know, I kid that it's taken 13 years for
Yes.
George R.R. Martin to come up with it. So they've used the same characters and whatnot. So that would be pretty clearly copyright infringement, even if a person did it, right? You can't use.
Well, that would be copyright infringement for other reasons.
Right.
Not,
So
not
what
recreating an existing work, but creating something in a universe, like the Prelude to Axanar movie, the
Right,
fan
that we've
fiction
talked
that we've
about,
talked
yes.
about in a previous episode, as our loyal listeners know. But what they're talking about in these lawsuits is not the output that the large language models generate. They're talking about the input that's used to create them, to train them. Because it can't, say, try to write The Winds of Winter in the style of George R.R. Martin, using his characters, knowing the backstory of the characters. It can't do any of that if it doesn't already have all of that information ready. And that means that it has to have read is in quotes,
Right.
all the other books written by George R.R. Martin. And probably it has, and probably a lot of related fan fiction as well. And not just that, but people's blog posts and people's tweets and
Right.
people's
Matt, a
everything.
follow-up question, if I may, about this. Because, okay, so if what they're alleging is that the software gets to read all these books, how is that any different, and why isn't it a defense to copyright infringement to say, I, Ken Parker, could read a bunch of books, and that's not copyright infringement if they get inputted into my brain, the training my brain to write, or any writer. Writers read a lot of books. What's the big deal? The software read the books.
That's true. There's, I think, at least two fundamental differences. One is a question of scale, and we'll deal with that quickly, because you and I, as much as you love to read, cannot read as much material as quickly as the software can.
So that's just a matter of quantity. How is
Yeah,
that?
scale.
How is that
Well,
infringement just because it's reading a lot?
it's not. But then, when it gets to the question of infringement and the possible defenses they have, I think that scale is relevant. And second, the other difference is that the large language models don't merely read once a transient copy of George R.R. Martin's other books, of Michael Chabon's books. They make copies of it. Now, the companies are very cagey about what they do and what material they've trained their AI large language models on. They haven't said. So far as I know, nobody outside the companies knows. It is probably a trade secret, but maybe not for long. Because,
and not in the Sarah Silverman case, which we can talk about in a minute, because they do know there.
And, well, there are other instances where people are quite certain that the large language models were trained on this particular book or that particular book. My point is, to train any LLM, it's implausible that they just read a transient single copy of a work one time and that was it. It's far more likely that they took copies of it, whether they were acquired legally or not, and made copies of them and held them, and probably still hold them in a very large database of lots of material that they've used to train not just the current AIs, but also the ones that they're working on now and for the future. So, and that, I think, is at the heart of these cases about infringement, that the infringing activity was making copies of hundreds of thousands of books to use to train these AIs.
I think you're absolutely right, Matt, but I want to put it in a little bit of a simpler way.
Okay.
Which is,
good.
When
Please
you
do.
or I read a book, we do not need to copy the book to read it. We look at the words, things go into our brains. We don't memorize every word of it. What happens when this software, quote, reads a book, it's not really reading a book. They're copying the entire text of the book. And in fact, it's like 7 billion gigabytes of books that they, or some ridiculous number.
Right.
We talked about the quantity, but even if it were only one book, they're copying the book to the computer. And that is what copyright is all about. So it's not reading, it's copying. And in fact, when they generate, they're generating sentence structures based on what's in those copies. So they're basically scanning through all this copied material and taking structures and substituting words and applying rules that to what they've already copied. So this is what's fascinating about.
Well, it seems like what they're doing is taking the books and not just, as you said, applying rules to it. That means things like determining how long sentences are, how many commas and semicolons get used in a sentence, how many subjects and verbs are in a sentence, and sussing these out as different styles so that when you ask ChatGPT or
to write in the style of George R.R. Martin,
it knows what that means, and it can do that. When you ask it to write in the style of Ken Parker, it probably knows what that means,
I hope it doesn't, but
you have a blog.
Yeah, well, the point to me isn't what it eventually spits out, because that could also be infringing if it uses the characters or the sentences or the paragraphs or the other fictional elements.
Sure.
But it's we know these lawsuits are predicated on the idea is that initial copying was infringement. Now, this is why what a federal judge has just done in the Sarah Silverman case is very surprising. U.S. District Judge Vince, I'm going to mispronounce this, but Shabria, granted a motion to dismiss on all but one count of a copyright infringement case. And what's shocking here is this wasn't about stuff that was in the public domain, even arguably. It was it included a copy of Sarah Silverman's relatively recent and still copyright protected book. And the lawsuit was against Meta, the company that owns Facebook, for use of its AI tools. But the book was part of a pirated database of books. So it was clearly they had no permission, and yet the judge still dismissed the case. Now, of course, it's just at the district court level. Presumably, it won't survive appeal.
Yeah,
but to me, this is and other circuits might not decide the same way anyway. But it doesn't matter what the output is. Right there, they illegally acquired it and plugged it into their model. So I think we should. So my footnote to this, Matt, is let's follow up and see if that Sarah Silverman case is appealed, and on a future show, let's make a note to update our audience on where this headed, because it's exciting, cutting-edge stuff.
It is. It is. And I think, looking over my notes here and some of the lawsuits, right? One, the author is Julian Sancton of that book I mentioned, whose title I can remember, Madhouse at the End of the Earth.
Yes.
Okay.
And which you recommend having not even read yet.
Well, I read a summary of it.
Oh, there you go.
But not from ChatGPT.
Okay.
I read a summary of it at Random House. I believe
Okay.
that was the publisher.
Right.
If I recall from this lawsuit and the stories about the lawsuit involving Julian Sancton suing OpenAI and Microsoft, they asked, I think the author, presumably, or the author's attorney, asked for a summary of the author's book and got a very detailed summary of it, which strongly suggests that the large language
ingested the
model
book, of
ingested
course.
the book. That's how it knows what's
And
in
it had to have ingested really means copied, and that's why
Yes.
we have the headline "AI ate my book" because
Right.
it didn't just read your book; it took the whole thing in and it's
Copied.
storing it in there.
Let's just use the word.
Yeah.
AI copied the book.
Yeah, it had to.
It's well, again, I think that some of their operation is at present a trade secret, and we don't know for sure how they do this, but it's hard to imagine a way that they could do this from what we know about how large language models work in general, not this one in particular, that it's borderline inconceivable that it did not make a copy of the book.
Well, it's so funny because, of course, there's the case where now the lawyer has been severely penalized for citing cases that don't exist because he asked ChatGPT to write a brief for him, essentially. And ChatGPT knows what a case citation looks like, but it doesn't know that those are actual references to real cases because ChatGPT is not intelligent. It's
Right.
not it's artificial intelligence. Fortunately, I think, is yet to be actually intelligent. It's just regurgitating things in an organized pattern. But you can't regurgitate what you haven't swallowed.
Yeah. Well, you know, the A...
Or copied.
Yeah, exactly. The A in AI would, I think, be better understood not as artificial, but as appearance. Because using these tools gives the appearance...
Apparent intelligence. I
Yeah,
like that.
it gives the appearance of intelligence. But they...
That'd be AOI, so that's why I like apparent intelligence, right?
That, yes. Let's just say yes. Do we want to go into any more depth?
I think we've worked this one over pretty well.
Excellent. Excellent.
So
we'll check back. You know, there's several lawsuits that are pending, and probably, maybe by the time of our next show, maybe later, we'll have updates on these cases.
Matt, what's our third topic tonight?
Third topic is about a trademark examiner, or really a court, taking
First a trademark examiner and then a court.
Yes, taking a bite out of Apple Computer and their trademark application and trademark rights, or maybe not their rights. So, I know that Apple Computer applied to register a trademark. They have several registered.
Apple has a lot of
I'm
trademarks.
lowballing this. I haven't looked, but they probably have hundreds of registrations. And in fact, they've employed some of my favorite trademark strategies. If you want to be really sneaky, they will sometimes, when they're going to roll out a new product, file an application in a country which doesn't have an online searchable registry of trademarks. I believe Jamaica is one choice they've used. And then you get 6 months from that date to file and claim priority to it. So they start their ability to claim trademark rights worldwide with a filing that almost nobody can find. And then they file, so that when they launch their product, they've already got trademark rights on file. Okay, that's not what's at issue here. In this case, Apple applied to register a trademark for music, but not just music. Tell us what it was for, Ken.
Well, so this is really interesting because it involves something we've talked about before, the old dispute between Apple Records, which was the Beatles label, and Apple Computer. And of course, Apple Computer originally, now they're just Apple, but originally they made computers. And they started with their first Apple computer, I believe, in 1978. Now, of course, this was long after Apple Records existed. The Beatles broke up in 1970. I think they may have continued to issue a little bit of something into the early 70s. But years later, as a tribute to Apple Records, because he was a big Beatles fan, Steve Jobs said, hey, I want to name my company Apple, right? So Apple was not in the music business at that point, though. Apple was in the computer business. And eventually they invented what many people thought at first glance was a bar of soap, but which turned out to be a music player called the iPod. Remember the original iPod?
I do, like a little block.
It was a rectangular, kind of rounded corners. It looked like, to many people, like a bar of ivory soap.
With
right?
a tiny screen and a little scroll wheel.
And a scroll wheel, a click wheel, I believe.
Yeah, that's right, a click wheel.
It didn't even scroll. It had like 4 things you could click.
Yeah.
And then of course Apple, as it got into the music business, at first it said, well, the first thing that happened was Apple Records sued and said, you can't do music because that's infringing our trademark. And Apple Computer said, oh, we're sorry, we're just touching over. And they settled the case, right? And they said, well, we'll get a very limited right to do certain things that you're not really doing that are music related. Then they started doing some more music-related things when they opened iTunes as a store. They went in, and so they were violating that agreement. They're doing tons of music stuff now.
Right, let's summarize in case any of our listeners either don't remember iTunes, either they're too young or they never used it.
iTunes still exists, right?
Well, I know it does, but not everybody uses it actively. Right. They have a piece of music software that runs on the computers, and you originally would connect your iPod.
And for 99 cents, you would buy a song. This is before you would subscribe.
So you could buy songs.
But people know that now on their iPhones, they can subscribe to Apple Music.
Right.
And they can get lots of. But iTunes was the tipping point that made Apple Records say, hold on, hold on, Apple Computer. In Apple Records, again, being the Beatles, the label the Beatles started, said, hold on, Apple Computer, you're violating our earlier agreement and you're going way beyond what you were allowed to do. And so they sued again, and once again they settled. And this time, rumor has it, it was for a whole lot more money, but clearly, as is now revealed by recent court filings, as people long suspected, but now we know for a fact, Apple Computer bought all the rights to that package of the trademarks, because now they're claiming tacking. In other words, they're saying we have priority going back to 1968 for the use of the Apple Music trademark.
Tacking, like pin the tail on the donkey tacking?
Exactly.
Where someone has trademark rights extending back in time, and you buy them, and then you have their rights.
You get there, and so basically, you're basically literally putting that tail all the way back. So it's crazy if you think about it. Apple is saying that it has rights to the Apple Music trademark for things it did years before it even existed.
Decades even.
Yeah, well, I think it existed in 1978, so maybe a decade. Okay. 1 decade.
Okay.
Yes. So yeah, exactly a decade. They're saying we have rights extending a decade before we even existed, based on these contractual agreements where they bought, essentially, in the settlement, those rights.
Yeah.
So fast forward to this lawsuit. So Apple, using all these strategies, is now registering trademarks like crazy. Everything Apple Music related, but they got a little greedy, Matt.
So in this application, which they filed, they claimed to be offering not just recorded music in different forms. Why they wanted to trademark?
So trademarks, as our audience knows, I think by now, if they've been watching a lot, trademarks don't give you the rights to a name with respect to everything. We've talked about before.
That's
right. You say Delta, you might mean Delta Airlines. You might need Delta Dental. You might mean Delta Faucet. And as you pointed out, Matt, you might mean Delta Tools, right?
Yeah, there's Power Tools. There's a software company.
There's all kinds of things named Delta. Yeah. You only get a trademark for the things that you've actually used it in conjunction with.
Right.
And so Apple, the now computer company, but now just called Apple.
But computer and music company.
Yes, the new registered Apple Music for a lot of things that they've never actually done, including live performances.
Right. And I think they're...
You want to pick up the story here, Matt?
Sure, if I may. I mean, I think their goal was to say that they wanted to have and build trademark rights for presenting live performances. I don't think the company itself was going to perform, so that if they wanted to, say, stream a performer or allow people to buy either a recorded or a live stream of somebody performing music through their Apple Music service or services, that would be protected under their trademark registration. And they put in this trademark registration application that description of services, live music performance, which is related to offering recorded music, which, bear in mind, they had tacked through Apple Music back into the 1970s, but which Apple Music, I don't think, had offered, and Apple Computer hadn't bought the rights to it. It didn't have those rights previously.
So enter another company that had been using something called Apple Jazz.
Yeah, it was I think a single performer or a relatively small band, not somebody on the scale of Apple or IBM.
I guess his name was Charles Bertini.
Bertini, right? Yes, but it doesn't matter because he'd actually used the mark Apple Jazz in commerce to identify himself as the source of these particular services, live music performances. Now, don't be thrown off by the fact that he's using the words Apple Jazz and Apple Computer is trying to register Apple Music.
Because they're confusing slimmer.
Because they're confusingly similar. And furthermore, jazz for Charlie Bertini is not a powerful part of that mark because
the dominant part is Apple. Because,
because one, it comes first, and two, jazz is presumably generic for the type of performance he does, unless he's, I don't know, electronic dance music or something. And I don't think he is. So he has rights.
And you took it to court.
And he took it to court because I'm not looking at my notes on the procedural history of the application.
Just to refresh your memory then, Matt,
please do.
What happened was the trademark examiner actually granted Apple the trademark. Apple said, we want Apple Music as a registered trademark with respect to live performances.
Or approved it, right, in the application process.
They approved it in the application
And what happens then after an application?
There was an appeal, of course.
Well, it gets opposed, right? Didn't it get opposed by Charlie Bertini?
And it worked its way up through the system.
Right, and then it gets,
appealed to a court without getting to all the steps in the
we don't need all the inside baseball.
We ended up before the United States Court of Appeals for the Federal Circuit, which is the court that ends up with all of the appeals from the Trademark and Appeals Board. All the trademark appeals go there. It's a court in Washington, D.C., one of two national courts below the Supreme Court level, and they deal with these issues all the time. And they reversed the examiner because they said, no, you can't tack. And the way they put it is, the party seeking to tack bears the burden to show the old mark and the new mark, quote, create the same continuing commercial impression so that consumers consider both as the same mark. And basically, what they were saying is, what Apple Records was doing wasn't live music, and it's not the same thing as what you're trying to ask for now. You're overreaching. What is really interesting to me about this, Matt, is that Apple is now precluded from, they had 16 things in that application. Because they had one that overreached, they lose the other 15. So in other words, getting greedy can doesn't mean they don't have some registered trademarks for Apple Music that they had in other applications.
They still have plenty of registrations both issued and pending.
Yes.
And the other things that were listed in this application besides the live music, it's not like they lose their trademark rights to them.
They may have some common law rights.
Because they don't. They still have whatever common law rights they had to the other listings in that application. I'm not looking at it, but say it.
If they had any, though, it's not clear.
That's what I'm saying. They still had whatever common law rights they had. And they're not foreclosed from trying to register for those things again. And in fact, if they...
But they had this precedent might stand in their way.
Well, yes, but... And I'm not looking at it. I know you have it in front of you. I think you have it in front of you.
What I have in front of me is some of the other things they've registered Apple Music for. I also have the decision.
But let's say in this application where they tried to register Apple Music for use with offering live performances. Say they also tried to register coffee mugs and water bottles and sneakers. Things that have no relation whatsoever. Presumably, they could have gotten registered if they weren't held up in the same application.
The tacking argument wasn't relevant, but they wouldn't necessarily have priority there.
Well, they may not. But because this application got stopped and they hadn't divided it, which they could have done, now, if they want to try and register for whatever it was, coffee mugs, water bottles, sneakers,
They'd have to start from square one.
they'd have to reapply.
Right.
But I don't believe they're foreclosed from doing so. They just have to get back in line.
So they have two problems. One is the getting back in line, and that for some of those things, they were going to rely on the tacking argument, which has now been smushed a little bit.
Yes.
All right, let's talk about a ethically challenged court and three of its recent decisions, shall we?
Let's do that. Okay. Let's start off with a preface, because you and I know we're both attorneys.
Yes.
In theory, it's possible that we might argue a case at the Supreme Court at some point. Perhaps unlikely, but it's possible.
Oh, certainly possible.
Okay. So let's hope that they don't find this and hold this next segment against us.
Well, as our audience also knows, we're trying to be a little bit entertaining. But,
we are. So,
but in all seriousness, the legitimate questions have been raised about financial favors and gifts and trips to members of the Supreme Court, very significant amounts, particularly with respect to Justice Thomas, but others as well.
But not only him, yes.
Yes.
But with him, definitely.
Yeah, and they were undisclosed, and so feeling the heat a little bit, it sounds like.
Well, let's point out that it's not just you and me
and
hundreds of other commentators who think that the Supreme Court has
members
had an
of Congress and the U.S. Senate.
And it's not just them either. If you read the introduction to their new ethics rules, which are their only ethics rules, as they've never had ethics rules
before. They're not
before.
actually rules, they're guidelines, though, right? That's another problem with
They start by saying, we recognize, I'm not looking at it right now, we recognize that questions have been raised about the ethics of members of this august body. No kidding, Justice Roberts.
So granted,
no kidding.
Everyone, I think at this point, understands there's some serious concerns. And every other federal judge, of course, has actual ethical standard rules that they must follow, or they can get booted from the bench.
That's right. But there are 9.
There's only 9 in the entire country, 9 judges at any level.
Right.
Even state Supreme Courts are all subject to ethics rules.
They have ethics rules.
They're the highest court in their state, but every other judge in the country, if they take a bribe or do something unethical.
Well, let's note that, as you just pointed out, Ken, correctly, these 9 judges on the U.S. Supreme Court still are not subject to ethics rules. They're now subject to ethics guidelines.
Yeah, and so, Matt, what's in those guidelines that has teeth?
Nothing.
Right.
That is correct. And that is the problem. That is, to my mind, the biggest problem with them, because they spell out a lot of niceties. We should behave ethically, we should disclose what we're doing, but it's missing 2 things.
Specificity, standards, and enforcement mechanism. That's 3.
I was going to go with enforcement mechanisms.
Okay, we're on the same page on that one. What's the other one you got?
Consequences.
Okay. Yeah, I also.
So I guess that's 4.
Yeah. So, but I mean, to me, what this is not a set of ethics rules to govern them. Not like the Mass Bar Association's rules that govern us as lawyers. The Massachusetts Board of Bar Overseers. You misuse client funds, you can lose your license to practice law.
Yes.
You engage in conflicts of interest. That sort of thing. Judges that take gifts from a party before them at any other court in the country could be removed from the bench.
Right.
This is not a set of rules. It is a set of arguments. The Supreme Court is arguing. They're not even saying we're going to do new, more ethical things. What they're saying is what we've been doing all the time, all along, is just fine. We just haven't explained it well enough. That's essentially what they're saying. Yeah. We have a PR problem, not an ethics problem, and that's what's fundamentally wrong with this document, because they're in denial on a certain level that they have a problem. They're like an alcoholic. I don't have a drinking problem. I'm just not explaining to people well enough when I drink, when I don't drink. I just need to let people know I don't drink in the morning. Yeah. That's what.
Here's the metaphor that I think of when I read these ethics guidelines, ethics argument. It's not like putting a fig leaf on Michelangelo's sculpture of David. It's like putting a fig leaf over an live, in-person pornographic film set and saying, this is fine. That's what I think it's like.
Anyway,
the Supreme Court from an ethics standpoint, is a raging dumpster fire. And these ethics guidelines do nothing.
Yeah, I mean, I think it may be a cliche, but I think it's true that power corrupts and absolute power corrupts absolutely. The higher you go in the power chain, the stronger the ethics rules should be, not the weaker. And here you get to the very top, and there's no rules at all. Thus, I think it's fair to say they are ethically challenged, at least ethical rule challenged, and some of them ethically challenged in the sense that they're behaving unethically.
Yeah. And to be fair, it's possible.
But we only have like 10 minutes left and 3
I know, but I just want to say that to be fair to the justices on the Supreme Court, it's possible that some of them have behaved completely ethically and have never violated any ethics guidelines.
And the vast majority of lawyers never get called before the Massachusetts Board of Bar Overseers.
But we don't know that because there's no disclosure requirement. And even if we do know it, there's no enforcement mechanism. There's no process in place.
There's no accountability.
For any sort of hearing or accountability. There's no way to trust that they're going to begin behaving more ethically in the future, those of them for whom we know they have had many problems.
And we will be fair to them.
For decades.
Matt, we will be fair to them at this table, though. We will be fair to them at this table.
Of course.
Because when they actually issue some real ethics rules, or when Congress imposes them, we will report on it and discuss it here.
And we'll thank them for doing so.
Yes, absolutely. Whoever puts those into place. All right, let's talk about a couple of their recent decisions, though.
All right.
All right, let me start out by asking you about one of them. We'll just do these real quick.
Yep.
Because, time.
Yes.
The Supreme Court recently decided a case involving Harvard University, one of our local commuter schools, I believe.
I've heard of it. It's nearby.
Yes, across the river there.
Yeah.
Across the Chuck. And apparently Harvard had a policy of favoring applicants who had some diverse characteristics in their background.
Right.
And the Supreme Court wasn't too happy with this. What happened?
So the plaintiff was some group called Students for Fair Admissions or something like that.
Yes.
They brought suit challenging the use of race or ethnicity as an admissions factor, and they won. That's the long and short of it.
All right.
The
so
court
Matt,
held,
how is this different from all those cases before that struck down affirmative action? What was different in this case?
Well, affirmative action had been chipped away at, but it was still able to stand to some limited extent. But now it's really done. You can't, so far as I understand, you can't use race as a factor in admissions decisions any longer.
So
but
you can't use it even for making your class more diverse? In other words, if the highest test scores and the best grades, if you just applied that formula, were all white males, then you'd have to take all white males. Is that what they're saying?
You wouldn't necessarily have to take all white males, but you couldn't weight the ethnicity or race of the applicants.
Can you weight if someone plays the cello? Is that okay if you need a cello player?
Yes.
So, okay. Yeah, no, I mean,
So, what I've seen and heard that schools are doing since this came down is they aren't asking for people's ethnicity, but they're asking about people's...
how they overcame adversity.
Right, people's experiences.
But no, they were asking prior to this about, and they had an essay question about how race played a role, or race or ethnicity played a role in their lives. Now they're asking a more open-ended question to which you can still give that same answer.
That's right, but the schools can't ask about it. I can't ask about race or ethnicity.
So it's don't ask, do tell.
I guess yes. I don't ever want to repeat that phrase, but yes, I think that's how it's working right now. And, I'm sure that this policy will get attacked by some plaintiffs. The fact is, college admissions and graduate school admissions have been fraught for many years, more than my lifetime, more than yours. And a lot of these policies that exist now, that's some people dislike, like legacy admissions or geographic diversity admissions. Those factors were created out of discriminatory intent.
Of course. I mean, that's the irony, is that they didn't strike down legacy admission. So if your parents went to Harvard, they can still be favored. You can be favored. But if you grew up poor and black in the inner city and didn't have the kind of opportunity, you can't get points for that. I mean, it really is a ridiculous.
Well, not by asking what is the applicant's race or ethnicity, or how the school can't
It is
ask.
true. The overcoming adversity could still count in your favor.
Right.
That is true. All right, Matt. One more question for you about this case, then we'll talk about the next case. Was this a unanimous decision?
No, I don't think it was.
No. In fact, it was what is it? I think it was a 6-3 with I believe that the Chief Justice, even though he sometimes switches over to what I would call the moderate side of things, the non-radical extremist side, I think he sided with the radical extremist side. So we only had the 3 moderates versus the 6 arch conservatives, essentially, which really goes to show you that these last 2 Trump appointments were quite effective at destroying affirmative action, and of course a woman's right to choose, among other things.
Among other things. That's a big one. Let's not just gloss right over that.
No. Anyway, so I think but our next decision did not split along those same kind of lines. More interesting.
Tell us about it, Ken. So I know the case was Counterman versus Colorado. Forgive me if I'm mispronouncing the guy's name. Colorado I know how to pronounce, at least as people in Colorado say it.
Colorado.
Okay. So this was a First Amendment case, right?
Yes.
Now, shouldn't this have just broken down along, my rights, my First Amendment rights, free speech, along
for whatever
those lines?
Reasons,
No?
Unless it involves religion, these things, there's some very interesting splits on the Supreme Court.
Yeah.
So it was a 7-2 decision. Elena Kagan wrote the decision, and I'm not a fan of this decision. I'll say that right off the bat, because what happened was,
give us the background.
Yeah.
So what are the facts? Because the facts,
all right, okay.
the facts always matter in a case.
So there, people are familiar with social media in our audience, and
I've heard of it.
There is a site owned by a corporation called Meta, called Facebook, and on this site, a fellow was posting a lot of very specific comments directed to one particular woman. This man was putting comments on like, oh, I saw you driving your Jeep Cherokee down Main Street, and I saw you shopping at thus and such a store, and you're a bad person and deserve to die.
Whoa, hang on, because those first 2 just sound like a lot of harassment. Potentially. I mean, you said, I think there were hundreds, right? Hundreds
and hundreds.
And how did he do it? Because didn't she complain and get his account shut down? And in response, he then opened up
more accounts,
dozens of new accounts every time one got shut down.
That's another problem with social media, is the inability to enforce. But that's not what this case is about.
My point is, I mean, he put forward. Oh, we've got a microphone problem, so I'm going to talk for a moment.
No, we're good.
The guy, Counterman, put out a tremendous amount of harassing content towards this musician, right?
Yeah,
but most of it was, not
right. I should say she's not a public figure, but she was out performing. So
yeah, a local performing artist.
Yeah, not a big name anyone had ever heard of. So here's the thing about it, though, right? There's a law in Colorado that says if you put things on social media that make people fear for their lives, that's tortious harassment. You can't do that. And he said, I had no criminal intent here. What I said were not true threats. I was just making comments, expressing my opinion. I was making observations about where this person was and expressed my opinion that she deserved to die. I didn't threaten to kill her.
So the fact pattern of hundreds of harassing comments from at least dozens of accounts in sequence, each one a new account because the others got shut down.
She was terrified for her life.
That terrified this woman and disrupted her sleep, her ability to perform, to earn a living, made her fearful to go out in public, made her cancel social engagements with friends.
Okay, and so what the court...
That was not a threat.
So the lower court...
Is that what the court said?
Yeah, so that wasn't a threat. So this is why it's a ridiculous decision, in my humble opinion. Because the lower court, I think, got it right. The lower court in Colorado, they said, hey, wait a second. even if he didn't have subjective knowledge that she was feeling threatened, objectively, these are threatening kinds of comments. And it was certain they applied a recklessness standard. He was being reckless, and the Supreme Court said, no. First Amendment trumps that. And so what you get to do is you get to say the most threatening things in the world, as long as it's not explicitly a threat, somehow that's okay. And this to me is ridiculous because people are sophisticated enough to like, hey, I hear you got kids. I know where they walk to school. Be a shame if one of them broke a kneecap on the way to school.
That's what threats always look like. Nice little liquor store you got here. It'd be a shame if something would have happened to it. That's a threat.
Of course. I mean, so this is, I think, an objectively bad and subjectively bad Supreme Court decision, and they should have kept the lower court decision in place. Just goes to show you that Justice Thomas, who dissented, this is one of the few times when I agree with a Thomas dissent. How about that? And,
well,
I'm sorry, it was, and Justice Barrett also. So Barrett and Thomas both dissented, and I agree with the two of them. It may be the only time that ever happens. Matt, I think we only have a minute left. Do you want to explain more v. Harper?
Sure. So very quickly, this was another split decision where a gerrymandered legislative map came up. North Carolina created a gerrymandered legislative map for elections.
Favoring Republicans.
Favoring Republicans very strongly. All the
They were
tricks.
trying all the little goofy lines.
All the squiggly
putting all
lines.
the blacks in one district, all
Right.
the Democrats in
Right.
one district.
Right. So that
Well, mostly it was done racially, of course. Because
mostly racially, but all taking a city and splitting it up so that the city doesn't get a
and again, the
wrapper
point
to
is to
itself.
get more Republicans in Congress.
Right.
That's what they're trying to do.
Right. And the state legislature said, you cannot review our work because we're the state legislature and we, under the Constitution, get to choose the time, place, and manner
So
of
basically what they
elections.
were saying is that the Civil Rights Act was unconstitutional. Civil Rights Act, Voting Rights Act, anything that said, I guess the Voting Rights
Yeah.
Act more specifically, they're basically arguing that this is the independent state legislature
Right.
theory.
I would like to just stick an adjective in there. The independent state legislature cockamamie theory.
Cockamamie, yes, it is quite cockamamie.
It
Maybe
is.
a 9.3 on the cockamamie scale?
Yes. And that's what the North Carolina state legislature was relying on. This cockamamie theory that the decisions that a state legislature makes about elections and about electoral districts cannot be reviewed by the federal courts at all. And guess what? The Supreme Court said no.
Well,
your decisions.
What was the vote on that, Matt?
I think it was 6-3.
This is what drives me crazy about this. There are 3 members of our United States Supreme Court who think the Supreme Court doesn't have the right to review this because the legislature can do whatever they want. Now, I think it's total hypocrisy on their part. If it were the other way around, these are very conservative justices, and if a Democratic state had done this and taken away Republican seats, they would be all over it. So I am just, I'm a little bit beside myself on this one. Of course they came to the right conclusion.
But the 6-3, I mean, that's already 3 votes.
Yeah, they just need 2 more for total insanity in this country.
Yeah.
I mean, throw out the Constitution. And the history is clear in terms of, Madison distrusted state legislators, and there was it's all in these guys who pretend to be originalists and want to go with what the framers of the Constitution's intent was. That's all out the window.
No. Originalism is originalism when it lets me reach the decision I want.
It's convenient originalism, right?
Yeah.
So anyway.
Ken, it's been a pleasure.
Yeah.
I know we got to wrap it up.
Yes,
I know we're at the end of our time.
We should do that.
Yes.
But I just do want to say that I give the Supreme Court an A on this decision. The dissent gets an F. But this is a very good decision.
Fair enough.
All right.
Ken, it's been a pleasure as always. I look forward to discussing more issues in the news.
From a legal perspective.
Yeah. With you
I
next
think,
month.
you know what, not next month being December. I do not believe we're doing a show
But January.
between Christmas and New Year's.
I'll see you
but
next year.
January, what is it, the fourth Tuesday of January, we will discuss these issues in the news from
a legal perspective.
a little bit more. And Thank you to everyone at home for watching.
Yeah, and thank you to our wonderful crew. We could not do this without you.
And everyone at New
Appreciate
TV. And so please have a happy and healthy holiday season, everyone. And we look forward to seeing you again next time.